Hello everyone and welcome to this Legal 500 webinar sponsored by Wolf Tice, Anti-Corruption, Compliance and Investigations in the Age of Remote Working and Collaboration. My name is Joe Boswell. I'm a senior member of the Legal 500's in-house legal research team and I'll be introducing today's session. We are very lucky to have an excellent panel here to discuss today's topic with a mix of both practical advice and technical knowledge set to be dispensed during the next 90 minutes that will help legal practitioners of all experience levels tackle the complex issues surrounding anti-corruption and compliance initiatives. If you have any questions throughout the webinar, please type these into the Q&A function and we'll do our best to put these to the panel at the end of the presentation. I'd now like to throw over to our moderator, Jitka, who is going to lead the discussion today.
Thank you very much for the great introduction. And I have to say, I'm very pleased to see that we have such a really large audience. And I'm very much looking forward to hopefully very active and lively discussion round at the end of our approximately 60-hour panel discussion. As mentioned already, we have hopefully put together a very interesting panel. We have different sectors involved in the panel or represented on the panel. We have different experience. We have in-house counsel, we have external counsel, we have sector-wise representatives from a life science sector, medical, we have commercial sector representative, automotive, we have external legal advisors, and we have external investigation, general kind of advisory. We should start probably with the introduction of the individual panelists. I would like to start with myself, of course. As mentioned already, I have the pleasure to moderate the panel today. I also had the pleasure to put the panel together. We had prepared, I'm quite convinced, very interesting set of topics and questions we would like to discuss first of all together among the panelists and then share our views with you subsequently, of course. My name is Jitka Logesová. I am partner at Wolf Tice and in charge of regional corporate investigation practice group. We cover 13 countries in Central Eastern and Southeastern Europe. We have Caroline Moffers. She is SFP, Chief Compliance and Integrity Officer at Elekta. That's the life science or medical devices representative on our panel. Sorry, she's very experienced compliance professional. She led the global compliance integrity function for Elekta since 2014, building basically really from the scratch a dedicated function and effective programs in areas of heightened legal and reputational risk and anti-bribery and corruption programs. And she is also focusing on trade compliance, competition law, and data privacy. We have another in-house expertise we have with Caroline Rees from Zalando. It will be a challenge for me to distinguish between Caroline and Caroline. I'll try to do that. She's also a very experienced compliance professional. She works at Zalando, and she is heading the compliance department there, or compliance and business ethics departments there. She also focuses on anti-money laundering and customs. Caroline is a trained lawyer. She also teaches compliance at the Berlin School of Economics and Law. And she's also a member of the advisory board of Deutsches Institut für Compliance. Another in-house member of our panel, or last one, is Lenka Kushnier. She is legal and compliance manager at Porsche CE. She's also a trained lawyer, my former colleague. She's advising, and that's, I think, one of her specialties at her current position. She is advising an exceptionally large number of clients at Porsche CEE, which is driven by the cross-company and department tasks, international nature of the business, and high level of entrepreneurial dynamism of the Porsche group. She is in charge of importers who are active in 26 markets in Central Eastern Europe. And we move on to the non-in-house expert on our client. First of all, I would like to introduce Thomas Brandy, who is a partner at law firm Selmer AS. He specializes in anti-corruption, anti-money laundering, and sanctions and export controls. He also assists companies with corporate investigation and crisis management, one of the reasons why we have him on the panel today. And he has also brought experience in assisting Norwegian clients to tackle various challenges related to fraud and corruption in the emerging markets. And he is frequently involved in cross-border investigation, which I personally can confirm as we worked on some of them together. Last but not least, we have Zoe Newman. Zoe is Managing Director and co-head of Global Financial Investigation at Kroll. That's, if I see it correctly, the only non-lawyer or non-lawyer position, at least on our panel. Zoe is a director in business intelligence and investigation division at Kroll, and she co-heads the global financial investigation practice, and she specializes in advising both government and corporate clients and their counsel in critical matters. And she, as mentioned already, focuses on fraud and corruption and also money laundering mechanism. Again, somebody whom we work very often together, and it's very good cooperation. So that's a brief introduction of the panelists. We will share respective information if needed after the panel today. Now, let's move on to what we wanted to discuss today with you. We, as already the title suggests, of course, we would like to discuss today various compliance challenges which companies are facing or were facing during the pandemic-related restrictions over the last year. The idea for this panel was more or less driven or triggered by lots of experience we have in this group collected during the time. And because of the panelists, we would like to cover the in-house experience, the external experience, and then put it together. On myself, if I can start very briefly with some kind of impression or sharing our experience we have done as an external advisor, advising clients on various compliance matters, but especially I'm corporate investigation, white-collar crime lawyer, when advising client on corporate investigation on actually conducting corporate investigation or representing subsequently or at the same time our clients being companies in white-collar crime proceedings or criminal proceedings. So the very high-level summary, which should serve as a sort of opening to our discussion, is that what we can see in Central Eastern Europe and especially in some of our countries, I will probably mostly stick to my home country, which is Czech Republic, is the following. We have relatively recently conducted, together with one of the leading Czech economical newspaper, kind of survey where we asked ourselves, or we were asked the question, among others, whether we see any increase or decrease on any kind of development in terms of crimes or not compliant behavior being conducted by employees. What the outcome of this, let's say, mini survey was, and it was published, it's searchable, is that in the experience of the external advisors who were asked those questions, we think that indeed in certain companies we can see certain increase of employment or of criminal activity which is being conducted by employees, and that the fact that number of employees are spending most of the time without, let's say, physical controls at home for some reason triggered this, supported the criminal activity, and we really see it. It cannot be generalized, of course. There are certain types of activity or criminal activity where personal meetings are needed, like most of the corruption activities, at least the bigger one. There at some point physical meetings are needed, but for some kind of accounting frauds or internal frauds, in many circumstances, the fact that people are not working from the office have the increasing effects on the criminal activity. This is one of the topics we will touch upon today. Another conclusion we will discuss from various perspectives today is that we can see in terms of criminal proceedings or activity of local prosecuting authorities, they are back on track again, unfortunately for some involved parties, but we could really see some kind of delay in criminal proceedings, because for a certain period of time, for example, witness testimonies could not, or interviews could not have been done. And this caused, of course, certain delays in the criminal proceedings. But definitely in Czech Republic, for example, in the cases we are working on, the criminal prosecuting authorities are really more or less back on track. It doesn't mean that at the end the criminal proceedings will not be longer. It will be longer, but the still stand, which we sort of perceived somewhere a few months ago, is not there anyway. Investigations, big corporate or internal investigation, big topic we would like to cover today. Is very important. So in most of our countries in Central Eastern Europe, it's being understood that to react appropriately to certain qualified, let's say, suspicions or allegations with a proper internal investigation and subsequent reaction is an ultimate condition for, at the end, the proof that company's compliance management system is working. We have, as I said, I will try to state the Czech Republic, not to be too general, but in Czech Republic, for example, really we have since 2016 the so-called compliance defense possibility, according to which companies can release itself from its criminal liability if they can show to the prosecuting authorities that they have implemented adequate measures to protect the company. We call it in the methodology which was issued a few years later in 2018, but by the Supreme Prosecution Office, in which I co-drafted, we call it, not surprisingly, compliance management system. So the corporate investigation are really sort of, well, let's say new trend in our countries. They are really being seriously conducted because most of the companies have finally understood that they have to, in certain circumstances, really to conduct it. What happened during the pandemics is that the internal investigation slowed down in our experience. And the reason for that was mainly the impossibility to conduct witness interviews in person. Topic we will be discussing today is how effective is the alternative way how to conduct interviews, which is via remote means. My personal opinion, or the opinion of my team, is that it's simply not that effective. You can't see that much body language is missing. You see just a part of the body language on the screen, and you are facing further risks. Again, we will talk about today, so that we, fortunately, I would say, for our clients, managed to postpone the investigation until the time when it will be possible again, even under certain restrictions or protective measures, to conduct those interviews. So we will, again, to summarize, and that's the end of my introductory part, we will try to discuss sort of general compliance issues and issues companies were exposed because of the pandemic, because of the remote working situation, and then we will also sort of focus on corporate investigation challenges during the pandemics. Well, now let's start to second part of our discussion today after we finish the introductory part, which will be that each of us or each of the colleagues will shortly share with us her or his experience, most important and relevant one from the pandemic time. I would and I think we should start, or the idea was that we will start with the in-house counsel and then go smoothly to the internal investigation external specialists. I would like to ask Lenka Kushner, so again, legal and compliance manager at Porsche CE, to summarize for us what in her role, quite a challenging one, the biggest really challenging during this period were.
Well, thank you for the introduction, Jitka, and good afternoon to everyone. Well, as Jitka said, PCE is the regional office and subsidiary of Porsche AG, and we are located in Prague, the Czech Republic. And we bring together 26 countries in Central and Eastern Europe. We claim that it is the most compelling and diverse and dynamic region in the world, and it brings together not only different cultures and languages, but also different legal systems, and that can be very challenging. Well, at the beginning of the pandemic situation, we of course challenged or faced a lot of challenges, as all the companies did. However, today I decided to share two topics with you. One of them is relating to business partner compliance due diligence, and the other one is rather employment-related compliance topic. As regards the business partner compliance due diligence, I have to say this plays a very important role in our practice. And prior to the pandemic situation, our professionals regularly visited our markets and conducted personal meetings in the markets. They provided various trainings, support. We ran Porsche Business Excellence program, and part of these activities were also devoted to audits in various areas of business of the importer or dealer directly in the market. Apart from this, we also conduct personal meetings with our potential investors. So if we have, let's say, a white spot market and we have an interesting business partner to talk to, it's usually the Porsche top management who travels to this market and conducts personal meetings with the potential investors, as well as checks the facilities where the business partner operates or the facilities from which the business would be conducted. Of course, this became very challenging during the pandemic time due to various travel restrictions and lockdowns. And yeah, we had to consider how to deal with the situation. So in fact, in relation to the white spot markets, we took the decision to postpone the tenders in these markets because we find it really crucial to personally meet the investors and personally check the facilities and places where the business would be conducted. As a second part, in relation to our current business partners, we also considered some kind of measures that we could put in place. And well, we implemented regular monitoring measures, which are conducted on 3 or 6 months basis. We have implemented these measures in relation to markets which we consider higher risk markets, or where we see that we could potentially face a reputational issue. And these monitoring measures are conducted by our external advisors who are actually located in the relevant market and who know the situation in the market very well and who can also speak the local language, because as part of this monitoring measure, we also monitor, for example, the local newspapers. So this was one of the topics. The second topic, which I mentioned, related to employment law and our professionals, because of course, at the beginning of the pandemic, we had to quickly switch to remote working regime, at least for some time. And as our team consists of professionals from many countries in CE as well as Germany, we of course considered for some time whether we could implement this remote working regime from abroad. And what seems to be quite easy is actually super challenging, because what are the topics that need to be considered here so that you as an employer stay compliant? So first of all, it is the labor law compliance, where in fact you should check not only the home office regulation in the country where your office is located, but also in all the markets where your professionals would be located. Then another part relates to compliance in the area of health and safety. Again, in fact, you as an employer should consider whether it is possible for you to fulfill all requirements in the area of health and safety. And this goes hand in hand with insurance topics, because, well, you might have faced similar situation, but at the beginning of the pandemic, a lot of insurance companies actually very strictly limited some insurance products which normally run very smoothly and which are usually used by employers on top of the mandatory insurance. Yeah, then next, what needs to be considered is equal treatment, of course, travel restrictions, lockdowns, and quarantine measures, which were actually changing very quickly, I would say, in certain time or even on daily basis. And then you can really carefully consider whether your employees would be able to get back to the country where your office is. And last but not least, the big topic which should be considered in respect of remote working is tax compliance. And this is a huge agenda, and it must be seen not from the perspective of the individual, but really from the perspective of the organization. And you, again, should check it not only in the home country, but in all the markets where your workforce would be located. Yeah, so these are the two topics I wanted to briefly mention, and I will hand over to Jitka.
Great, thank you very much. That's of course very interesting. I'm probably Caroline Rees could follow up now and perhaps share one of those comments or support them. But in general, Caroline, you seem to be a real remote worker professional. What are your 5 minutes high-level most important experience you would like to share us from pandemics?
Yeah, sure. Thanks, Jitka and Lenka for framing these topics, because yeah, you're right. Working at an office job at Zalando at this moment means working remotely. So we are facing a lot of the challenges that Lenka is mentioning with regard to tax and insurance compliance, to cover what we call new work, yeah, for all the staff that is at home office at the moment, that I'm at home office at the moment. But obviously, being a huge online retailer across Europe, this also means logistics, yeah, and our logistics colleagues. So approximately half of our workforce doesn't have the choice to do a home office because you can't pick and pack remotely. So we continue to have a strong employee on-site presence. At the same time, with all the central functions, including the compliance team, working from home, which is a very specific situation, in fact, that we never faced before. So my 5 minutes would be, in fact, about how to efficiently steer investigations during pandemic times, yeah, because as you mentioned in your introductory statement, Jitka, obviously when the first pandemic crisis hit us, we thought it would be for a very brief time, right? So we prepared for returning to the offices within a few days or at least weeks. Postponing investigation work, to be honest, was never my choice, yeah, but obviously you thought that you could have online visits, online interviews in due course, which is not the reality. And at that time, at the beginning of the pandemic situation, actually what everybody was thinking in the compliance world was that investigating remotely was literally impossible. Yeah? And reality proved otherwise, I believe. Yeah? And we all were on a very steep learning curve to that regard. So my 5 minutes would be in fact about the challenges, but also the opportunities that brings remote investigation work. Yeah. So with regard to the challenges, some of them have already been mentioned here. Yeah, you don't have an on-site presence, which means especially interviews, which are the critical at the heart of our investigation work usually. Yeah. Except for very few exceptions, are different. Yeah, they do exist, but everything you learned in your career and experience about body language, and also looking at on-site team dynamics, for instance, it won't happen. Yeah, you won't have these insights, which is of course a strong disadvantage. Yeah, let's not sugarcoat that part. With all of the, let's say, more legal and psychological challenges that come with that. Yeah, you can't really, check whether somebody has a technical issue, for instance, during an interview. Yeah, so people have an option to drop out that is not there actually when you're in the same room with them. So this is one of the major challenges, obviously, that you don't get this on-site impression. And another fact can be that gathering documents or data can also be more challenging when you're not present at the site you're actually looking into. But on the opportunity side, I would also like to mention that there was a learning that in remote times you can be very efficient. Yeah, you are able to schedule interviews at a much higher pace. You don't have travel time. You don't have to respect geographical limits, for instance, when choosing the interviewer. You just choose the best suitable person. And also the interviewers, you will never have, let's say, a judgment call on whether it's worth to interview this person, yeah, because it's so super easy and efficient to do it remotely. Yeah. So probably there's also an advantage in remote investigations. Yeah. Plus one additional comment on gathering data and documents. If you have trouble to get the information remotely, you probably should have a closer look in whether your control system and access management and data management system is suitable, yeah, irrespective of your current investigation. So this is another chance to take a step back and to see whether this scales, yeah, in a geographically diverse group of companies, and whether you have all the access rights you need and you require. So to sum this up, I guess there are two learnings or questions you should ask yourself to reflect on what remote pandemic situation means for your investigation. The first one is there maybe an ally on site you can leverage? Yeah, is there a trustworthy site manager or HR person or other contact, yeah, advisor that is close and could have an on-site look at what you're missing because you can't travel there. And the other one is just to reflect on what it means for your investigation plan. Yeah, so not to rely on that what you have always done is now true, yeah, because maybe you can speed things up or do them the other way around or in parallel where you don't have the geographical limitations. Yeah, so I would rather like to have an optimistic look on what we learned during remote times, and maybe use some of the techniques even in the future. Once we can travel again, still my educated guess is that the on-site interview, that meeting with people you're interviewing will come back, yeah, and will remain very, very relevant in the future.
Thank you very much. So we are slowly moving also to the corporate investigation part, and in this trend, I'm sure Caroline, of course, will continue. Caroline was, and we are again changing sectors or medical devices. Caroline, what are your experience, or what is your experience you would like to share with us?
So hello everyone, thanks for introducing me. So I think there are two questions, and the first one is sort of whether or not to investigate during a pandemic. I mean, we all know that ourselves as well as our companies are facing unprecedented challenges during the pandemic, and are mainly focusing on the COVID impact on operations, well-being and safety of employees, and the new digital ways of working with customers and so forth. So we all know that internal investigations drive resources and frankly can be quite costly. So we all recognize that while the focus for companies is mainly here and now, it is a bit tempting to postpone an investigation or sort of delay the start of it. This brings me to consider a few things in connection with such a decision. And first thing is that, well, the pandemic is not over. We don't know when it will be and what a new normal will look like. So therefore, it's difficult to sort of take a decision and understand what the bearings will be. And I also think that there is a risk during COVID that I've witnessed myself here in my role, that COVID is seen as an exceptional circumstance, and therefore that certain workarounds could be tolerated. People are not complying with processes as they usually do. And I think that for that reason, there is a risk that a pandemic actually can heighten the risk of certain misconduct in a company. So I would caution anyone who is considering to delay or even postpone an investigation. And I think, first of all, bad news usually don't get better as time goes by. And if the allegation pertains to potentially criminal activities, of course, the most urgent thing, as you alluded to already, Jitka, is that we need to prevent further misconduct. So that's for a first priority to make it stop. And also, the delay of an investigation also means there is a risk that data can be compromised. Individuals can leave the organization. Generally, I think it will be more difficult to gather information as time goes by. And then I also think of another impact, and that you think of your stakeholders. There is, as you know, a tremendous increase on transparency reporting and many sort of different stakeholders to consider. I think of regulators and enforcement agencies. I have not seen that they have been slowing down their activities, and they really expect you to take the internal measures as you sort of witness potentially criminal misconduct. And I also think about a very important stakeholder, that is the board. So I think any decision should be taken by the ultimate authority in a company, by the board, to sort of delay or postpone any investigation. And then I also think about sort of other stakeholders, such as media, investors wanting information, and to sort of carefully consider your communication plan if you decided to postpone or delay the start of an investigation, and why sort of things were not properly looked into or stopped. So I think my experience from the COVID times is that I do recognize that it is always better to have a face-to-face meeting, but I think we have adjusted to new ways of working, and it has worked out quite well. And I think even if times are turbulent and the focus may be different for companies to sort of safeguard their business, I think individuals have generally been more available this year. So that brings me to the next topic, what sort of the opportunities of COVID, if you may call it an opportunity, is that we have had time in the compliance team to work closer with the business, because there was less travel, maybe even less business opportunities. So we could do more risk assessments, we could interview our employees, we could sit with leadership, and we could look into past transactions and prepare sort of plans for how to improve our program. So that's my sort of final recommendation, that it is turbulent times, but there is also time to tidy up a lot of policies, procedures, and ways of working.
Thank you very much. Could you perhaps in this sense sort of formulate your conclusion that there are, as you mentioned already anyway, that there are also positives of the pandemic situation? As you said, people are more available, you have more time, so that this is a probably possibility. And some of the businesses, we see that there is again a trend going up, but still it's probably, or it used to be, a slower phase in relation to businesses. That is basically was a good time to take up certain compliance tasks, like trying to really remedy or update compliance management systems and processes, because normally I can imagine that there is a more push and other priorities than compliance. Can you sort of see that that might be the positive effect of the pandemic situation?
Absolutely, I've definitely seen that.
Yeah, okay, thank you very much. Well, moving to the external advisors and their experience, I would like to ask Thomas to summarize his 5 minutes opinions, on views on what the pandemic brought us and what were the challenges in particular to corporate investigation, but maybe to general compliance task.
Thanks, Jitka, and hello everyone. So as Jitka told the introduction, I'm a partner here at law firm Selmer, being an advisor to Norwegian companies on the corporate compliance and investigation area. And so my main observation will be relating to corporate investigations. But before starting on that topic, I would like to share some observations on ESG and corporate compliance in the context of the pandemic. So when we had the corona outbreak in March last year, of course, it resulted in an uncertainty on business impact for many Norwegian enterprises. And for companies that did not have in-house compliance resources, that is the vast majority of Norwegian enterprises, corona did definitely put a hold on internal compliance processes. And now that the financial insecurity for many of our important industry no longer is present, compliance is pretty much back to normal. However, we see that travel restrictions have made it challenging to conduct in-person audit of business partners, such as agents and intermediaries. This is, however, to my opinion, to a certain extent doable on digital platforms. I think that the more critical point is the challenge of conducting supply chain audits and factory inspections in the emerging markets in the context of human rights and working condition compliance. So there is definitely a lag on this important area. And I think local third-party consultants can, of course, be engaged and have probably increasingly been engaged in terms of conducting audits and inspections. But however, for a large Norwegian retailer with important supply chains in the emerging markets, such work cannot be 100% delegated to external parties. So I think that is the snapshot from a, so to say, Norwegian compliance ESG perspective in the context of the pandemic. On the topic of remote corporate investigations, of course, typically involve some degree of travel and human interactions, particularly for the evidence gathering and in-person interviews. I hear there's some echo here, probably someone should mute. And so we have conducted cross-border investigations during the COVID pandemic. My main observation is that it has been manageable, but sometimes also quite challenging. The first main point on what have made it challenging is the confidentiality considerations. So remotely conducted interviews pose certain challenges, of course, to maintain an interview environment that sufficiently protects the confidentiality of the interview. So first, there's a risk, of course, that the interview is being recorded without the company's consent. And third parties may also be physically present within earshot of the interviewee. So securing a robust environment for the remote interview has therefore been key. But even with certain measures on, you cannot be 100% sure that there are any confidentiality, so to say, challenges. And sharing sensitive information has also been challenging. Usually we would let an interviewee have access to and comment on relevant documents in a physical meeting. And sharing information during the pandemic has been and can be also challenging. Firstly, because of the sensitivity of the documents. In some cases, it may be appropriate to share screens with the interviewee or provide the documents on a secure portal in advance. However, sharing or providing documents remotely runs the risks that the interviewee takes copies of the document. For example, take photos of the screen of sensitive documents. And of course, also due to the number of documents in larger corporate investigations, it may be impractical to share documents. And in any event, the general principle when we conduct corporate investigations is that the interviewees should only be shown documents that they have previously seen or which concern them. And the second main point goes to the lack of physical interaction, which has been previously addressed in this webinar, and especially when interviewing key individuals to the investigations. I must say that having done corporate investigations for 15 years, responding and reading adequately the body language is really a key strategic factor when conducting interviews. And obviously, it can be challenging to read body language via Teams. So I think that one observation is that remote interviews are better suited to pure fact-finding interviews with witnesses than interviews with individuals potentially involved in the wrongdoing. So I would say that if possible, I would postpone those really heavy and important interviews until physical interaction is possible. And then in that context, of course, a key consideration is that what Caroline addressed, if there are any risk for potential ongoing illegal activity, and that interview is necessary to further investigate that risk. Of course, digital interview perhaps may be the only solution. And as for the remediation side of the investigations, that is the follow-up tasks. These are also sometimes affected by the pandemic situation. For example, disciplinary actions should, to the extent possible, be delayed until it can be done in person. On the self-reporting side, these processes have also seen some challenges due to the physical close down of the prosecutor's offices. Self-reporting by teams in a grand corruption matter is obviously not the ideal route for a company. And the big legal question is, of course, if and to what extent the challenges related to the lockdown will be taken into consideration when the prosecutor assesses the remediation efforts in the context of corporate criminal liability. And finally, a short observation on the cross-border cooperation among the prosecutors. We also read in the newspaper that have been examples of challenges among Norwegian and foreign enforcement authorities due to the travel restrictions. Yeah, I think that sums it up for me, Jitka.
That's great. Thank you very much. Just here, one comment or question, open question. You mentioned also some of the challenges we are as investigators, but also companies facing when in situations where the interviews are being conducted remotely. And the question in this regard, which needs to be, and you mentioned a risk, which we see as well, that if you are sharing information, documents with the interviewed person, and the person is then taking a screenshot, this document, if the document will leave the hands of a lawyer, where it's normally under our, probably most of our jurisdictions where representative panel protected by legal privilege, this legal privilege will be then not given.
Yeah, of course, that's a valid point, Jitka. So also due to the legal privilege consideration, it can be a really challenging situation. I also hear some echo now. So
yeah, that was me. Not it. Okay.
So what we really normally would do would of course, in a physical meeting, in a meeting room, sharing information with the interviewee, but of course not providing the interviewee with that information to leave the room with that information. I think that is of course a key factor when conducting investigation, and that control of that sensitive information you to some extent lose by showing information on Teams or a digital platform.
Thank you very much. And I think from a practical point of view, in certain countries, so this increased attention of what we are what kind of information we are sharing and how we are sharing the documents or information in general is important, perhaps not particular, but in particular in relation to countries which incorporated so-called reporting duty. It's quite a specific in our countries, in some of our countries in Central Eastern Europe, for example, Czech Republic and Slovakia does it. There is a general reporting duty for everybody, only external lawyers working on a case are exempted from this duty to report to the enforcement authorities any allegations or suspicions, and the level is already at the level of suspicion in relation to certain crimes, especially bribery, active, passive, direct, indirect, one of our main challenges or goals when we are structuring internal investigation in those countries with those reporting duty, and we possibly or we are exposed possibly to corruption allegation, is that we really need to be very cautious not to trigger this duty on the side of anybody. Well, talking about employees, but in some circumstances also board members. So how to deal with information, especially in times of remote working, is really a key. Now we move on to, as a part of our introductory sessions, to last panelist, which is Zoe Newman, Managing Director from Kroll. Zoe, you have vast experience with conducting internal investigation. Well, basically, we are doing only this. What would be your 5 minutes summary on lesson learned from the pandemic situation?
Thanks, Jitka. Sure, I'll try and keep this quick so we've got time for questions. But I think the biggest lesson learned sort of picks up, it's not good to come at the end, but picks up on Caroline's point and Caroline's point. A lot of our work tends to be on behalf of clients that have problems overseas, in overseas markets. And obviously that's a big problem because we can't get to the overseas markets that we would normally go on the ground to. However, that's not been so much of a problem, surprisingly, at all, because so many corporates now have got good systems in place, that have got integrated accounting systems. We can pull the records, emails on a cloud, so it's very easy to pull email discreetly without employees knowing, etc., etc. Again, in terms of our external research into transactions and beneficiaries, we can do most of that around the world from our computers nowadays. The issue is, of course, getting the records of that support accounting transactions and the same. And we've had to create various clever ways of getting those, whether it's through a remote internal audit that's on our behalf, or some sort of procurement compliance review, etc., etc. You have to be a bit more clever, particularly when you're doing a discrete investigation. Again, to go to Caroline's point, big trend I've noticed over the past 3 to 5 months has been compliance being very proactive. And I think it's sort of almost that point where they've had maybe a pause for breath and are able to take a step back and think, actually, the environment's so different now in that we're operating under. It's time to do a renewed bribery and corruption fraud risk assessments. It's time to stress test what we've got in place and see whether or not that's appropriate. I guess the biggest issue that we've faced and seen impacting corporates, I guess the most frequently asked question, probably you, Jitka, Thomas, myself, are asked all the time is, has fraud and corruption increased over the last 12 months? And I guess sort of the consultant's answer is to some extent yes, and to some extent no. What it really is the situations increased. The situations increase the opportunity for wrongdoers to commit fraud. And of course, that has increased enormously. So have we seen a large uptick in internal fraud corruption investigations? No. I think probably most of us agree that much of that is only likely to emerge as the world resumes a sort of business as usual operating environment. An internal audit can get back out into the field, and the external audits are completed on 2020-21, and compliance has got a greater nexus to the business. What we have seen, though, is a huge uptick in external attacks on corporates via organised crime. So it's sort of the external fraudster as opposed to the internal wrongdoer. And those frauds have taken many forms, whether they're sort of your classic fake CEO, CFO frauds, phishing attacks, email spoofing, whaling, where vendor bank details changes are made. And to succeed, they all rely upon the weakness, or I guess naivety, if you like, of the greatest risk to a business, which is its employees. And the fraudsters of today that do those external attacks are supremely sophisticated and targeted, and are hitting thousands of corporates a day to find, you know, the weak spot, and almost, I guess, behave as a sophisticated international corporate themselves. And those frauds have got much greater in value. You know, they used to be sub a million. Now we've worked on ones that are in the tens and even hundreds of millions of dollars in terms of how the corporate's been attacked and breached. And the issue is that obviously the lapse control environment, and the longer employees are working remotely, the greater the gulf between the corporate and the employee. You can't just sort of nip next door and say, does this look strange to you, in terms of an email to compliance or to legal, or just, you know, the person that sits next to you at the desk. And the nature of corporates that are being attacked are the big international corporates with foreign subsidiaries, where it's the foreign subsidiaries being attacked. And what we found is, in terms of the problem for corporates, is it takes longer for those frauds to come to light because there aren't the chats in the corridor, etc. And therefore the money's gone and it's been dissipated and it's been laundered. So actually getting it back, let alone investigating what's actually happened and how it happened, they cannot notice sometimes for 6, 8, 10 weeks after the event, even when tens of millions of dollars have gone. So I think what we've seen corporates doing much more nowadays is to really make use of the accounting data at their disposal and conduct much more proactive data analytics to pick up patterns, trends, red flags that may be a perfectly explainable transaction, but so that compliance is more informed with some of these red flags and can touch them straight away, as opposed to wait for sort of an employee to blow the whistle or it to emerge elsewhere.
Thank you very much, Joy. I have one question for you. We're just discussing it recently. As we are in general moving more to the area of remote working, remote researching, or online researching, there is what is your experience? How we are when researching, or for example, conducting background searches, have the outcome of those searches be impacted how we tend to, or especially I would say perhaps the younger generation seems to take the information which is publicly available, so just take it at the face value. What do you think?
It's one of my greatest bugbears, but I think yes, they've probably been nagged enough not to. But I would say what I've noticed is now people, there is so much to access in terms of data online. It should be treated as an initial lead that then needs to be followed up with corporate record extraction. So you know, I started out at Kroll as an analyst 20 years ago, and some of our greatest yeehaw moments came out of actually pulling the full file out of the BVI corporate registry, because the fiduciary had left a file path at the bottom. So we always sort of hammer home war stories in that regard. But one point I really would make, Jitka, is the ability to interrogate and mine social media is actually giving such more context now to online research beyond the corporate registries. So really being able to mine, you know, tens, hundreds of people's Twitter accounts at the same time and look at who they're connected to. When you're trying to look into procurement and kickback investigations, look to see how people are connected to each other. Actually, it's making, you're able online to get much more context around relationships than you ever used to be able to, as long as you're sort of using proper data analytics tools that can really mine that information efficiently, as opposed to trying to use the human brain on its own.
Thank you very much. And I think we are now, because we we spent an hour with discussing between each other, or within ourselves. Sorry, English is not great. Now we can move to the discussion and answering, trying to answer some of the, or we'll see how much we will be able to cover some of the questions from the audience. I have seen it already. They are very interesting. And when the first one I would like to start, which is really the first one in a chronological way, is a very important one, very interesting one, and I'm sure that everybody would be able to contribute. The question is, how is social media impacting how a company handles communication around an investigation when it becomes public? The media hears about it. This is, I would say, a favorite topic. All of us have been able to spend a lot of time around this. Perhaps, Zoe, because I still see you on the screen, what again would be your answer, your experience?
I think it's a big problem. My experience is that, particularly on leak of information investigations and similar, or any kind of major public relations issue faced by a corporate, there's been plenty of media reports where boards have made shoot from the hip statements too early in advance of having the facts. And then that escalates the whole social media frenzy around the issue. So I would say nowadays the advice is very much to sort of get that initial fact gathering assessment before you do anything on social media. Is my advice. I would just say also, more broadly as a trend in terms of investigations, the use of social media influencers, I've noticed, has become much more topical, depending on obviously what industry you're in. But I've seen much more proactive work being done on what social media influencers said in the past and how that can influence and impact the reputation of the organisation. So we've done many more social media influencer audits and reviews to look for sort of how that can impact.
Yeah, thank you very much. And also, I think what needs to be taken into account is the fact that also the prosecutors are reading the media, and that's why it is really so important to make sure that if before anything on behalf of the company goes out, we are pretty sure that it will not fire back. We had an experience a few years ago where we were conducting an investigation which was started by, the company itself started to conduct the investigation, and in an immediate reaction to publicly raised allegation in relation to public tenders or bid rigging, corruption sort of allegations, they reacted immediately and saying that they will investigate it, that everything is wrong, of course. They will investigate the allegations immediately and appropriately, that they have engaged a Big Four company, and that they will publish the report at the end. Not a good idea. At the end, the report was not publishable, neither in a way to give it to the journalist, but also not in the way to give it to the prosecutor. But the prosecutor waited for a few months and then asked the advisor to hand over the investigation protocol. But at that time, the structure of the legal advice was done properly, and the investigation was not done by this non-legal advisor. but by us, so we could remedy the situation. But really, lesson learned was it might be emotional at the beginning. Of course, it's a lot of pressure there, but really wait to be sure and really analyze the situation properly before you make anything public. And I'm sure that this is something where also my other panelists would like to cover. I just would open the floor. Who would like to react on that? Probably from the companies, somebody as well, Thomas, whoever.
I think that, from a Norwegian perspective, I think that it is one observation is that corporate criminal matters are handled less transparent and less public than perhaps you would find in, for example, in the US, where you have, these plea bargaining matters where you disclose the agreements entered into between the corporation and the DOJ and so on. So in Norway, you typically have neither from the company nor the prosecutor any, so to say, statements or detail leaked in public. So, I think that it's fair to say that we seldom see, so to say, social media information regarding a corporate criminal investigation. However, that could change going forward. But I don't think that social media to any extent is impacting how a Norwegian entity would go about to handle communications surrounding an investigation, because the standard answer would be no comments and yeah. so not much, so to say, public information surrounding these kind of processes in Norway.
Yeah, thank you very much. And I would be also interested to hear a view from the company side, in-house views. I don't know if anybody would like to comment.
Yeah, sure. I mean, I agree. Think twice what you publish, yeah. But this is obviously something that does not only apply to social media. So I think we need to distinguish the proactive or the reactive use of social media. Yeah. So the first thing is obviously you need to monitor what's going on in social media. Yeah. So this is part of what your press department should cover. Otherwise, you cannot react to, for instance, false allegations or things that are discussed that are utterly untrue and harming your reputation. But for statements, I believe it's not so different. To be honest, it feels very different, because it feels very informal, but this is a trap. Yeah, it is not so different from press work and press statements, to be honest. Yeah, because you need to be prepared to go public with facts and results. Yeah, so I guess I completely agree. I couldn't agree more with what you said. Yeah, so you need to be ready to make a statement. Yeah, not only an emotional statement saying, "Oh, this is shocking for us," yeah, but a fact-based statement. And probably you're not able to do so. Yeah, as part of the management or the compliance team before the investigation is completed. So don't be trapped by the fast pace of social media. Treat it like press.
Yeah, thank you very much. And media monitoring, by the way, especially I think Lenka perhaps could share a few comments with us. Media monitoring, especially in, I think you used the term white spot markets, and in general a little bit more challenging markets, is also, I think, quite important part of what should be done, and perhaps part of the usual checking and compliance processes. Lenka, how do you deal with media reports and monitoring in your practice?
Yeah, well, we definitely changed the approach in this area during the last few years because, I mean, hiring a big international company for compliance screening of a business partner where you have already some doubts. We have found out it's not the perfect solution, and we have to always reach either through this international law company or otherwise to a local council, because we found it very crucial that you can learn a lot of interesting things via monitoring of the local newspapers. And for that, you have to know perfectly the local language. Plus, it's very helpful if the council has a deep understanding of the situation in the relevant market, not only the business situation, but also the political situation and what is going on in the market. For example, there can be already investigations running or some court proceedings which have already some attention. So yeah, we find it very, very important part actually of the compliance due diligence process. And as I mentioned, in relation to some higher risk markets or where we already think we might face some bigger reputational issues, we even conduct this local monitoring on a 3 months basis to be in a picture, to have good picture.
Yeah, I think what might be also quite a big challenge is to make, and then we are again with the issue of how to take certain information or whether at the face value or whether a little bit more resource related and reputation related analysis is needed. It's also very important, I think, to see and make the distinguishing between the sources of the potentially reputationally damaging situation. And I would say in particular in our markets, we are now talking mainly about Central Eastern Europe. So we have a number of sources which are not independent in their views. That's probably everywhere, but that's quite a problem in our countries, definitely, I would say. Thank you. So another question for in-house counsel specifically, which is, it's a broad one, interesting one as well. How do you as a company create a culture of compliance? So big question. How do you make it easier for a potential employee to blow the whistle on an issue without feeling guilty or concerned about their own job security? I think we can answer this question. So the question was put for in-house counsel. I think we can especially try to answer it in the light of the fact that the European Whistleblowing Directive will be implemented in all of our countries. In Czech Republic, there is a law already which has been passed through the parliament, which deals with the question of protection of whistleblowers and specifically deal with some with issues like an obligation to implement as a part of compliance management system an anonymous whistleblowing line. And in addition, the law also involves an obligation put on the companies to make sure that the allegations are being properly investigated. In our view, those obligations, like the need to implement some kind of whistleblowing anonymous solution and the obligation to investigate is already in the law. It's a part of the compliance defense regulation. But well, in this case, it will be even stressed again. So it's the whistleblower protection is, I think, quite important or even more important topic nowadays. Who would like to take it from our in-house counsel?
I can give some preliminary comments if you want, Jitka.
Yeah, thank you, Caroline.
So I think you covered the basics there, Jitka, and I would like also to say that the fact that the whistleblowing directive will be implemented will not sort of change so much for how we are dealing with these questions. And I think the culture of compliance and the speak up culture, they go sort of by hand in hand. And first of all, I think there needs to be an appetite for people to report on sort of potential misconduct or sort of other concerns. And that means that it needs to be encouraged from the top leaders of the company. And of course, basically, you need to have the infrastructure there for people to be able to report anonymously if they wish so. But so what we have done is, since a few years back, we implemented a yearly survey, which is different from the sort of all employee survey that is run by the HR function every year. So it's a survey that is focusing entirely on whether people believe that in the company, leaders and managers are walking the talk, which is expressed by the code of conduct and the compliance policies, for example. And the question specifically evolve around whether employees believe that something would be done if they reported something. And these observations that are collected through this yearly survey are presented to our management and the board, and we sort of track on a year-by-year basis sort of how they evolve. But I basically think that most important is that not only the compliance function raises the importance of speaking up, but that it definitely comes from the top and the board and the management and so forth.
Thank you very much. Just one comment. I'm looking at the question again, and would like to share one particular experience. When we conduct internal investigation, we of course very often ask for the information how any suspicions or allegations can be anonymously reported within the company. So what kind of tools are available, and if the employees are really using it. And then we ask, of course, for the proof of this use, so that we can check that that the reported incidents are relevant in a way that they show that the employees are really trusting the system and the possibility to report via anonymous company whistleblowing system or not. And this is one of the questions which is being asked also by the prosecuting authorities, by the way, as a part of their question, which relates to the question whether the compliance management system is set up effectively in a way that the company potentially can release itself from the criminal liability. We have, for example, in one case, were asked by the prosecutor to show what kind, because we argued that we have a lot of information that actually the whistleblowing channel is being used, and then it was a really big global company, and we were able to provide information, very few information over 2 or 3 years, with quite smallish or irrelevant complaints. And the conclusion of the prosecutor was that it shows, it can be, it's a big company, risk sector, etc. It can be that the companies or that the employees are really trusting this whistleblower channel because there must have been more information. You can argue with it, explain, but that's what happened really in one particular case. And then another sort of war story where again we were conducting an internal investigation and asked those questions about what is in place, etc. We were told that there is a box where each employee can put the complaint, and when we asked for the content of the box of the period of, I don't know, 1 year, the answer was that there was never a complaint filed, which is not positive. And we asked where the box is located, and the box was located in the entrance area, where also camera was above the entrance box. So, well, this kind of reporting really doesn't give the employee obviously any comfort that it will be dealt appropriately, and that he will be really facing no consequences. In terms of feeling guilty questions, we have, again, especially in our markets, I have very often heard in the past the comment that people, I don't know, Czech Republic, because of its communistic past, are afraid to report non-compliance because they feel that they will be reporting on, well, in the similar situation as previously in the old regime, reporting to the people, to the authorities. I can't confirm from my experience, and I'm in this business also for more than 10 years, that this is, at least now, I don't know what the situation was 10 years ago, but now I don't think that that's the main reason why potentially the people would be hesitant to report. What I have seen in terms of reasons for not being hesitant to report within the company's certain non-compliance is a loyalty to certain people, or say false loyalty, but not that they would feel guilty, or as discussed before, that they are not feeling secure. Would anybody else like to add something on this? I think quite important.
Well, I can add few words on that. My experience is that people are not shy within Porsche to actually raise any concerns they might have. It might be some little concerns or even some bigger concerns, and I think this line is used quite frequently. Our employees can actually choose whether they want to address a topic via a local compliance help desk or directly through a central compliance help desk. And of course, they have the possibility to use the anonymous line. Porsche uses Ombudsman, which is actually 2 external law offices. And this can be used even in local language so that the employee feels comfortable about submitting what he or she really wants to submit. And as you mentioned, Jitka, some fear about submitting these tips, I think it's clear, and it will definitely apply in most of the companies, that there are some, let's say, basic principles of which are applied in relation to whistleblower system, and unless something is really proven and investigated, it's clear that there won't be any consequences. And of course, the whistleblower is protected.
Okay, thank you very much, Lenka. There is a question which is directed directly to Thomas. How is sustainability changing the way in which companies look at their long-term models following a crisis?
Wow, that was
big one.
A big one, and partly it can be interpreted in different ways. I think that well, obviously we see a big wave of ESG and sustainability now flowing into at least the Nordics, and in Norway in particular. We have legislation now on social standards coming up next year, legalizing, so to say, the OECD's guidelines on human rights. So that's a milestone for a Norwegian legislation perspective. So I think that I don't know whether this corona crisis in itself has changed the way companies looked at their long-term models. From a, so to say, crisis perspective, I would see that it has shown challenges to ensure sustainable practice within the corporations, in more particularly relating to human rights and working conditions, due to the lack of those really important targeted compliance measures like audits and due diligence. So yeah, I don't know to the anonymous attendee if that was a good answer. So, but you know. ask any follow-up question if this was too blurry.
Yeah, thank you very much, Thomas. If I see subsequent question, I will raise that. Was another question I wanted to quote, which relates to, I think, processing of data. There were a few questions, some of them relate to monitoring of employees and some of the relates to processing of data during internal investigation. And I think that, I'm just trying to find it, but I think on one general comment, a lot of people do not understand that what we are doing on internal investigation is not monitoring of employees. Monitoring of employees is a process which is strictly limited by provisions of respective employment laws. What we are doing is, and monitoring means in most of the jurisdictions I'm aware of on Central Eastern Europe, is sort of looking in the real time what the into the communication of the respective employee. What we are doing, however, on our investigation is not monitoring. We are not looking into what the respective employees or custodians are currently doing, but we are reviewing past or historical business-related communication. And for this kind of exercise, the consideration or restrictions we need to analyze and take into account are especially privacy laws and well-known GDPR legislation. And well, to sum up, we can say that internal investigation must be really conducted in such a way that the risk of breaching privacy laws are minimized. That's, by the way, also one of the reasons why we are using specialized technology for reviewing the emails and respective documentation, because by setting up the respective keywords, we can almost exclude the risk that we are entering or reviewing private information. And all the conditions must be assessed on case-by-case basis, and what needs to be taken into account are, on one side, the interest of the company, and on the other side, the interest of the respective employee. And one part of this process, how to analyze what is appropriate and can be done, is the so-called legitimate interest assessment, which the company have to conduct prior processing the relevant information. Would anybody from the panelists would like to add something on this? No, okay. There is another question which I think relates to what we have briefly touched upon. Please share your experience. Whether is it possible, whether a NDA is required before a virtual meeting, and how to balance between commercial and compliance interests. What is your advice to your clients, managers? I think it's more for us external advisors. Thomas, do you have an idea, or no, not idea, opinion on that?
I'm not sure if I get the question 100% right.
Well, the question is whether a NDA, I think we, if I understood the question correctly, we were, it's possibly a follow-up to what we have discussed when we talked about risks of conducting internal investigations remotely and sharing certain information remotely. In my view, NDA is not required, so we don't need to. We are lawyers. We are protected by our duty to confidentiality. So in my view, there is no need to conclude any sort of NDA document. But it was a question asked here.
Yeah, I think that's a good summary. But of course, in a corporate investigation setting where you share information virtually, of course, by sharing sensitive information, you're possibly, you're no longer have legal privilege on that information, as we discussed earlier. So an NDA would, of course, not repair that. It would still be a risk that legal privilege is waived by sharing it with employees or external third parties. So in the context of, say, corporate criminal liability matters, an NDA would not mitigate the risk that there is a leakage of sensitive information that would harm the organization. Of course, an employee is, of course, obligated to treat that information, according to his obligations as an employee. But as a main point, starting point, we would never, so to say, provide an employee or a third party with sensitive information in an investigation if it's not absolutely necessary. That was, my angle is more a corporate investigation than a general virtual meeting. So
yeah, thank you very much. And as we see that we have spent our time, but I think that we have time at least for another question. Zoe hasn't had the opportunity to talk for a long time, so I think that's a question for you. For example, when starting an investigation, how do you get the right people in the room? What is the best way to conduct forensic analysis remotely?
I saw that one, Jitka, thank you. I wasn't sure about whether when they say right people in the room, they meant to do the investigation or in terms of the subject. So I'll answer it both ways. I guess, in terms of the investigation itself, if you're talking about how do you get subjects into the room, the right subjects into the room, quote unquote, whether it be virtual or physical, the key answer to that is don't start interviewing until you've gathered facts to begin with. So you need to understand what the issue is, what the allegation is, understand where that further information might be in the accounting records, where it might be in the email records. Then you understand who knew what when, the circle of knowledge. Then we feed that to you, Jitka, or you, Thomas, or others, and then the interviews start. So that's the right way of sort of using the forensic analysis to get to the right people to begin with. In terms of the right people in the room, it really depends on the organisation. I mean, some big corporates have got bigger investigations teams than Kroll. It's being cognizant, really, I think, as to when you're either going outside of your comfort zone in terms of skill set, or I think most importantly, cultural understanding. You wouldn't want to send somebody that had no clue about China or no clue about Russia to go and do an investigation on the ground in either of those jurisdictions, because they'll go in with their eyes wide shut and not find anything. So to me, it's really being cognizant on a case-by-case basis as to what your in-house skills are, technically as well as culturally, and where you're coming up short and may need to go outside to supplement that.
Thank you very much. We are now a little bit over the time, and many participants left already because they have, as we have full schedule. I would perhaps suggest that we conclude. There are a few questions which remains unopened. We will figure out how to follow up on them and answer them and come back to you. Before we really close, I'd like to open the floor for any comments, final comments for the panelists they would like to share with us or make. Don't be shy.
I mean, I just think that without being doom mongering, I think sort of we're entering into sort of pause, breathe mode, and it's going to be the next sort of couple of years whereby it's really needed to be understood sort of what's happened and how, particularly accounting misstatement fraud, people pumping up revenue numbers, that type of thing. I suspect it's going to be that kind of issue that we're going to need to be more alert with as the world returns to normal.
Exactly, thank you very much. And I think it also partly at least respond one of the questions whether we see any kind of impact on the level of criminal activity, especially corruption activity. In relation to the pandemic, it's probably indeed too early to say. First, we are still in the pandemic, and typically this kind of more sophisticated criminal activity takes some time to be relieved. But you all read newspapers. There's a lot of allegations already, for example, in relation to public purchases of masks, for example, and similar items. But we will probably see. But from the normal criminal corruption perspective, I think we mentioned it also today. I think that corruption is a kind of activity where personal contact is more required than, for example, when we talk about cartel-related, cartel-related activity. Probably it will be the same. You also need to meet with people and discuss. And there are other kind of activities, internal fraud, where you don't need to potentially, in some cases, meet with people. So we will see. That's usual legal and depends. It's a usual legal conclusion. Anybody else? Some kind of what comments? Okay.
One short reflection I see from all the regards and the greetings from the participants that there is a truly international webinar. I think that's really cool. And the greetings from Ecuador, Kuwait, Morocco, Montenegro, Mauritius, Germany. So we have the whole globe attending. I think that's shows the international aspects of compliance.
It's true. Okay, then let's conclude really also officially. First of all, I would like to thank the attendees for the time they spent with us. And as I said, we will follow up with the questions which remained unanswered. And I personally would like to thank to the panelists for not only for the time, but for efforts they spent and for the experience they shared with us. And I also think or hope that the seminar or webinar was useful for you. And I also hope that at some time, hopefully soon, we will be able to meet in person again. Thank you very much and have a nice day.